Good morning. We are here for oral argument on the State of Arizona versus Ricky Alonzo Hippensteel. It's our number CR-25-0203. Both sides experience counsel. You know you may keep whichever time you like. For rebuttal, just keep your time yourself. Please proceed.
Good morning. My name is Damon Rossi, and I represent Ricky Hippensteel. I'll try to reserve 4 minutes of my time for rebuttal. I'm hoping to make 3 points today. First, the jury received conflicting instructions on how to deliberate on provocation manslaughter. Second, the instructions, when taken as a whole, funneled the jury away from provocation manslaughter before it could even learn what adequate provocation means and doesn't mean. This was a misdirection that the verdict form also reinforced at the moment of decision. And third, instead of applying a proper objective analysis, the Court of Appeals denied relief based on its own speculation about how this jury handled the conflicting instructions. Starting with the instructions themselves. They amounted to competing commands. The lesser included offense instruction, which came for second-degree murder, had a reasonable efforts element to it, which was proper.
Counsel, is there any disagreement that there is an error here?
There is no disagreement that there's an error. The disagreement fundamentally is about prejudice.
Perhaps that's what you can focus on, of how does that constitute fundamental error?
It constitutes fundamental error because it goes to the foundation of the case. The foundation of this case became, once the jury acquitted him of first-degree murder, and once it found that justification was not, there was no justification, the degree of homicide became the key issue in this case. And the erroneous instruction went to the foundation of that and impacted deliberations on that.
Counsel, can I ask a question? Because how you're discussing foundation of the case, it seems that that would be a rather malleable concept depending upon where we're at in verdict forms. And the way I understand it, the foundation of the case, you've got to take into account, well, what was the defendant's argument? And in this instance, I mean, from the opening statement, from the get-go, it was, this is a case about self-defense. So at what point do we move from defendant's overt statement to the jury that this is about self-defense to all of a sudden, depending on where the jury is at in considering a particular verdict, that then becomes the foundation of the case? Help me understand that.
Well, if it goes to a key dispute, and I think that the instructions and where the jury arrives at its decision triggers whether it goes to the foundation of the case at that point. When the jury decides there's no first-degree murder, there's no justification, now it becomes a key dispute, the degree of homicide, and that's where it goes to the foundation. The other thing that it impacted was it also, I believe, impacted prong 2. The reason it impacted prong 2, because it effectively, the way these instructions worked out, they denied an essential right to that defense. Talking about prejudice.
Well, what was the right to the defense?
The right to defense was to have the jury receive proper consideration of adequate provocation. And because these instructions conflict with one another, and because we can't really engage in speculation about how they handled that conflict, it's depriving any assurance that he received due consideration of that essential defense.
In light of these concerns, why isn't there prejudice under prong 3 of Escalante?
I briefed the cases prong 1 and prong 2 below. I do believe, in retrospect, there is probably reason to find prong 3, and I think I briefed that in my supplemental briefing as well as my response to amicus. I believe it's prong 3, especially if the court were to look at the Lua instruction and determine, is the Lua instruction itself adequate?
Well, on that point, I saw that in your supplemental brief that you were questioning the adequacy of the instruction itself because it doesn't reflect that the state has the burden of proving the lack of adequate provocation. The Court of Appeals didn't address that at all in their opinion, which made me wonder, and I haven't had a chance to go back, but did you raise that to the Court of Appeals or to the trial court?
I'll be perfectly candid. We did not raise that issue. I believe that looking forward, though, it's an issue that this court is going to want to deal with. I also believe that it's not necessary for Mr. Hippensteel's grant of relief, and that's what I said in my response to amicus. I believe that by looking at prong 1 and prong 2, we've met that standard, and then we go to prejudice. And when we look at prejudice, I think what the Court of Appeals did is it speculated, where we were not speculating about what this jury did. We were looking at an objective basis, absent the erroneous instruction, which is what Escalante would tell us, a reasonable jury could have found for a different verdict. To me, it's actually even more compelling that if you have conflicting instructions, it's less likely they're going to come to that different verdict than if you have the right instruction.
Counsel, let me ask you a question about that, because our case law also tells us that when we're considering issues like this, we're supposed to look at the parties' arguments, their theories of the case, the jury instructions in totality. And if we're doing that here, I think we're also supposed to take into account how the instructions were delivered to the jury. And I'm wondering if you've given any consideration, or if you would comment on whether the fact that the jury was given their final jury instructions before closing arguments put in their minds at least twice, not being argumentative, just saying that this is what they heard, at least twice about how adequate provocation can be considered. And I think this is different than what happened in other cases where maybe the court instructed the jury after closing arguments. Does that make a difference?
In this case, I don't think so. And the reason is because not only did the court read those instructions, but it also read the verdict form to them. And it read it to the verdict form to them twice. And the verdict form emphasized the erroneous instruction. If you read the verdict form, it says, you don't go any further if you find second degree. Stop. And so I think once before the jury retired for deliberations, and then I think the first or second day of deliberations, the court brought them back because there was an unrelated typo in that verdict form, and it then reread that verdict form to them. So it was emphasized to the jury twice. I also think that, to go to your point about, well, there's other cases in which maybe this was, I'm thinking about Eddington. I don't know if that's what you were getting at, but
there are several.
Yeah. In this case, I would argue that to assume that the jury read the first instruction and necessarily evaluated provocation manslaughter, I think is erroneous, because the first instruction tells you if you find sudden quarrel or heat of passion through adequate provocation, then you go to then you find manslaughter instead of second degree murder, but it doesn't tell you what those terms mean. Behind the gate of the reasonable efforts instruction, it tells you what those terms mean. It tells you what adequate provocation means and what adequate provocation doesn't mean. But you don't get to that because of the gate that the reasonable efforts instruction gives you, which is if you find second degree murder, stop. Or if you're hung, you can go beyond this. But in this scenario, a jury's not hung on second degree murder. They found the elements proven. And they haven't found him not guilty of it yet. So that gate it makes the Lua instruction that was given before less compelling, that the jury actually gave adequate consideration to it, because the definitions of adequate provocation and cooling down and all of that, they're behind the gate of the reasonable efforts instruction.
So if on the prejudice calculus, since we are to consider for proceeding under prongs 1 or 2 of Escalante, what consider the parties' arguments, the evidence, and I'm sure we're going to hear at length from Ms. Jones about this, but I'd like you to address the fact that it seemed that justification was the primary defense, and that's fine. It doesn't foreclose consideration of an alternative defense, but it seemed that the manslaughter defense, in terms of the argument, defense argument, was bordering on an afterthought. What's your response to that? Why should that not foreclose our conclusion that there was prejudice in this case?
Adequate provocation, to my way of thinking, is often, maybe this is not the perfect term, imperfect self-defense. The jury heard evidence that this was a heated argument, that my client was rousted up in the early morning because somebody thought he might have stolen a tractor. He goes over because he knows that the victim had some involvement in it, and the victim is refusing to talk to him or the people. He's getting increasingly agitated. He's waving his knife around that he's using to cut some wires on the car, and in the process, as he looks out of the corner of his eye, he says the knife comes down and nicks him in the hand. And he said at that point everything went black and the fight was on. That's the evidence of adequate provocation. I agree. Defense counsel's primary defense was justification, but defense counsel also made it clear in closing that it understood the jury may not find justification. And he argued in that case it's not murder.
So the evidence the exact same evidence would go to those lesser offenses, right? Obviously, the grand prize for the defendant here would have been a finding of justification, but the same evidence would go to either type of manslaughter.
That's correct, Justice Paul.
So then in considering the issue before us for prejudice, we have to look carefully then at what that evidence is.
Question again on this.
Sure. I'll say it more as a question rather than a statement. So then it would seem that we have to give careful attention. Would you agree that we have to give careful attention then to that evidence to determine whether or not defense counsel's brief statement about adequate provocation, we've got to look at that carefully to determine whether or not a reasonable juror could have found that was adequate provocation to render a manslaughter verdict.
The court could do that. However, the judge sat through the trial. The judge heard all the evidence. He saw what occurred. The judge believed it was appropriate given the facts. The state actually disagreed with one of the lessers, not this one.
Oh, excuse me. I'm not disputing that there was enough there to get the instruction.
You're talking about prejudice.
I'm just talking about, again, for what we're supposed to do in that prejudice analysis and looking at the instructions and the parties' arguments and evidence here for the recitation of evidence that you just mentioned that would get to adequate provocation. If we're supposed to determine whether or not a reasonable juror could have rendered that verdict, then it seems we do have to pay particular attention to the actual evidence in the testimony. Would you agree with that?
I think certainly you would be, in evaluating prejudice, you would be looking at that. And I think in other cases the court has done that. I think in one case where the case name escapes me, the court said, look, there was no evidence or argument that could have supported that theory of defense.
And is that Fierro, State versus Fierro? Well, and that's what I was going to ask you, because that's a recent case, State versus Fierro, just a few years ago in the context of an incorrect jury instruction based on a Raji. I was going to ask for you to kind of talk about it, the fundamental difference, because Fierro was cited here, and maybe that's your answer, is that there was not the same argument in Fierro as there was here. But if you recall Fierro, I was going to ask you to just talk about the fundamental difference in the area of prejudice from Fierro to here.
If I recall in Fierro, the erroneous instruction was attempted murder based upon attempted second degree murder. And there was an instruction that was included that you could commit attempted by acting recklessly or knowingly, I think. And the court said, that's clearly fundamental error, but it's not prejudicial because the defendant argued exclusively self-defense, and there was nothing presented in trial that would have supported that theory. And so I believe it was Justice Bollock that actually issued the opinion. Justice Bollock for the court, and Justice Bollock remarked that if it had been different, it certainly would have been more, I'm not going to put words in your mouth, but it would have been very much closer to prejudice. I think the court said it would have been prejudicial We can argue whether that the court was firm on that or not, but I think it certainly was a stronger argument. And that's what happens here, because it is relevant to the defense, and there is evidence.
Who asked for the, I know, the adequate provocation insert to the second-degree murder instruction?
What happened in this case is defense, while discussing jury instructions, said I want a lesser for, I think he said I want a lesser for manslaughter and negligent homicide. None of the parties submitted written lesser instructions. The court said, okay, I'm going to give it. I don't know if the court at that particular moment remarked, I'm going to give adequate provocation and reckless, but when the court then gave the instructions, the court is the one that gave those instructions.
Put that in there. Oh,
yes.
I mean, I'm wondering, does it indicate that at least the court thought that it was adequate provocation as it impacts second degree was an issue? Otherwise, why is it in the jury instruction? Because that is just an insert. I mean, you can be taken out of that instruction, can it not?
Yes. And for those reasons, Your Honor, I'm going to ask the court to deny relief based on speculation of the Court of Appeals rather than a proper objective analysis. And I'm going to ask the court reverse and remand for a new trial. Then I'll come back on rebuttal. Thanks.
Thank you. You came in right at 4 minutes. Great.
Not usually that.
That's rare. It's a rarity.
Yes.
Ms. Jones.
Good morning. May it please the court, Alice Jones from the Attorney General's Office on behalf of the state. This case really turns on the standard of review. It turns on that Mr. Hippensteel bears the burden of showing that the error was fundamental and prejudicial. And I want to start on the fundamental prong because the state has only agreed that there was confusion in the instruction and an error occurred, but not that it rose to the level of fundamental error. And when there's fundamental error in jury instructions, it usually impedes a defense. It doesn't allow the defense to argue something, to argue a defense, to argue for a lesser, or it doesn't allow the jury to convict someone of a lesser. Neither of those things happened here. Mr. Hippensteel could fully argue for provocation manslaughter. Nothing impeded his defense attorney from doing so. And he could have asked the jury to convict him of provocation manslaughter. It's unclear if he did. On kind of a refresher read for this oral argument, when I was looking at pages 94 to 95 of the March 6th transcript, his lawyer, so the primary defense was justification, and I think his attorney said something to the effect of, okay, if you don't believe that and you go to murder, it's not premeditation. And he really focused on premeditation and said it's not, it's second or maybe manslaughter because of the instant quarrel, heat of passion. And then he gets back to premeditation. The definition of premeditation includes instant quarrel, heat of passion, that it can't be that to be premeditation. So it kind of is unclear to me if he's even arguing provocation manslaughter there or actually just negating premeditation. This jury certainly wasn't told what was asserted as adequate provocation. And everything was discussed in two ways, that it's justification by either self-defense or crime prevention, or it was not first-degree murder. So I think this is really different than an instruction where it doesn't allow them to assert a defense. It doesn't allow them to go to a lesser.
What's your best case for that proposition that they usually, if it's fundamental error with an erroneous jury instruction, that it deprives someone of making an argument? Because in Fierro, I think the quote that was just discussed, an erroneous jury instruction could lead an objective, reasonable jury to reach a different verdict if the error relates to the defense against the charge. That seems a little different, less onerous than what you're saying, that it would have to deprive the defense of an argument.
So two things. I think Fierro, fundamental error wasn't I don't see actually a very robust discussion of why the error was fundamental. In paragraphs 1 and 20 of that decision, it kind of is just, it's fundamental. And I read that case more as touching on prejudice. I go back to Escalante and talking about, the types of things that it relieves the prosecution of a burden of proof, impacts a key factual dispute, deprives the defendant of a constitutional or statutory right. And so I'll admit I don't have a specific case on, but I was looking at this court's past cases on instructional error, and that really is what it is when it doesn't allow the defendant to be convicted of something lesser, and that's not what this instruction did. I'll admit it was confusing, but the jury was told, it was given the Lua instruction that in order to convict of second-degree murder, you have to reject provocation manslaughter.
What about the definition, though? I'm sorry to interrupt you.
No.
The definition, because that is something that, I get the Lua instruction doesn't have the definition. I don't know if others would then commonly be given alongside it to give that definition to kind of cure that, but it struck me as odd that if you're reading through the jury instructions, you get the instruction on second degree, and if it's guilty, if it's all the elements are met, consider provocation. But because there's no definition there, I would just think the jurors would use their own common sense, what they think individually that means. And then you go on to the next instruction, and it says you don't need to get there, don't even bother. Well, it doesn't say it that way, but the verdict form does. But essentially, it applies if you find not guilty on the first two, the first or the second, and then it defines manslaughter. So, and provocation, what that means. Did they juries need that definition in this in context with the Lua instruction to be able to sort through this and make a reasoned decision? So, first I'll do globally. That's why in the recommended jury instruction, the fix we have does pull that definition up. So I do think it should be moving forward with the definition of I think that definition does need to be there. Here, as one of the justices commented, the jury instructions were read in full before closing arguments. So they already heard what adequate provocation means in the reading of the full jury instructions. I think there's a way to read these instructions and not that there's two ways to convict him of adequate provocation. First, we have to reject it to convict him of second-degree murder. But if we're unable to agree or we decide he didn't commit second-degree murder, then we get another chance to convict him of provocation manslaughter, considering it with reckless manslaughter. And when we're speculating about what the jury did in fundamental error review, that a defendant can't show entitlement to relief, because that is not, fundamental error review means that we didn't have a chance to cure this at the trial court, and now it's got to rise to a really high level, that rare case that we're now going to reverse it. And when we're speculating about how the jury read these instructions and whether they did one thing or another, to grant Mr. Hippensteel relief, we have to believe that they completely ignored that sentence or in the Lua instruction, that they had to reject adequate provocation.
Counsel, on that topic, the Court of Appeals opinion says, if we presume the jury followed this instruction, which we must do, then the jury could not have checked the guilty line for second-degree murder on the verdict form until after it considered and ruled out provocation manslaughter, because the provocation manslaughter instruction is embedded in the second-degree murder instruction. It would be pure speculation and imaginative guesswork to assume that the jury did not follow the entire correct second-degree murder instruction. But isn't the Court of Appeals there speculating that they did? Because you have just indicated that there are more than one ways to read the instructions.
I do think there are more than one ways. I think but
isn't that itself speculation?
But we're under fundamental error review. And so when we have an instruction that gives a clear command to the jury, like the Lua instruction did, and we're under fundamental error review, I think what that really is meaning that we have to then say the jury ignored that the jury ignored that, and we can't presume that they ignored that instruction because they were confused when they got to the later instruction.
But what if, I don't think that we have to assume that they ignored the instruction the portion of the Lua instruction that said they have to consider adequate provocation. But as the chief asked, isn't it possible that they just sort of surmised what that meant in the context of that instruction? Because if they read the instructions sequentially, they would have stopped right after that. And why isn't that the inference that we would draw, that a jury would read the instructions sequentially? And if they did, they would stop.
Because the whole instructions were read to them before we got to closing arguments. So they were told in that time that adequate provocation has a meaning. And so I think because they didn't go into the jury room without the instructions as a whole being read to them. So I do think they heard at some point that adequate provocation does have a meaning given to it by the instructions.
But my concern is slightly related to that yes, okay, they read on or they heard from the court what that means. And maybe they even read and reread and tried to figure this out. But the definition is only in the manslaughter part, and it's even though the same terminology is used, it's not in the second degree. And it made me wonder, I mean, has it been, it seems like it hasn't been defined at all for purposes of second degree murder, which could that reasonably be taken as meaning that the definition in the next instruction is simply inapplicable because it's only applicable to the manslaughter?
I think when we start getting into speculating what the jurors thought, or if they didn't think that definition applied earlier, that's not how we grant relief under fundamental error review.
Well, I'm not asking to speculate, actually. I guess my question is, I'll ask it this way as a yes or no. Is adequate provocation defined for purposes of the second degree murder instruction?
Not with the second degree murder instruction, no. It's later on in the instructions.
So it's a no for second degree murder, it's just yes for manslaughter. And that's what I'm wondering. That's not speculation to say it's not defined for second degree murder. So is that viewed through that lens, would that show that a reasonable jury could have applied a different definition to provocation in making its decision?
Again, I think it's highly unlikely when they're told there is a definition for adequate provocation. And I think that would be strange for them to assume, well, we're defined it here, but it must mean something different here. I don't know why they would necessarily assume that when there is a definition given to them of what adequate provocation means. And then I do want to jump to, and I don't want to avoid the question, so if I haven't answered it, okay. I do think ultimately the adequate provocation, the definition was given to the jury, just not next to the second degree murder instruction. So if we move on to prejudice, then I do think we have to evaluate the evidence and look at all of the evidence in the case, and not just the defendant's testimony. And the standard to get the instruction is very different than the standard to show that a reasonable jury could have returned a provocation manslaughter verdict here. We have multiple eyewitnesses, and multiple eyewitnesses talked about that Mr. Hippensteel came to this property, made a threat, and I do think we consider that, even though they didn't find first degree murder, because it still goes to intentionality. So maybe they didn't find that it rose to the level of premeditation, but it still goes to intent. That he had a knife, multiple people saw him with a knife. That he went to go confront, and he started the confrontation with the victim. That no one saw the victim fight back. That it was, I think someone described it as almost, colloquially a sucker punch, and that matched the physical evidence that he was stabbed deep in the neck and deep in the chest. These were deep stab wounds, 3 inches deep. I think one cut bone. And even though he claimed he was stabbed in the hand, he was apprehended by police the next day. And when he talked to police and chose to talk to police, he said, if I was there, wouldn't you expect to find marks on me, bruising? And he had one scratch on his hand This did not match his testimony that he was stabbed deep enough that it bled, that he had to wrap it up, and that it was a deep wound. And again, he gave conflicting, his testimony at trial did not match what he told detectives. So there is some physical evidence that really casts a lot of doubt on Mr. Hippensteel's testimony. And so when we're considering whether a reasonable jury could have returned a different verdict here, you have to look at that in light of all of the evidence of the case.
So counsel, is your argument then that given all the other evidence and testimony from witnesses, that it's just as conceivable that the jury could have rejected the defendant's entire version of events, which would have obviated any consideration of adequate provocation? I want to make sure I understand your argument.
Yes, I think so. I think it was a matter of, I do think that they obviously rejected justification, and were going to the degree of murder. Must have thought there was not enough for premeditation, which is it was charged as premeditated first degree murder based on the threats and the initial threats. But I just don't think there's evidence here supporting even the adequate provocation, because again, the jury wasn't even told what is being alleged as adequate provocation, but if it was being swung at with a knife, then the physical evidence didn't support his testimony that he was stabbed in the hand.
And let me clarify one thing too, because I think I might have, when I asked opposing counsel a question, might have misunderstood that my thoughts about the adequacy of the evidence to get the instruction in the first place. Your argument is not that he shouldn't have got the instruction. Your argument is that even with the instruction, there was insufficient evidence to establish adequate provocation.
I think that it's a much lower standard to get an instruction.
No, I get that.
Yeah.
I'm clarifying this because, again,
okay. Yeah, no, I understand.
When we're trying to consider prejudice here, and we're supposed to, my term, look at the totality of the circumstances, what we have in front of us, how these different components line up is, for me, dispositive. And one road takes you down looking at just the final jury instructions and going through it in a very serial fashion. Another road says, well, you have to look at it within the entirety of how those instructions were given to the jury. And then you have to consider the evidence. Then you have to consider the parties' arguments and the actual theory of the case. I think where you end up depends on which road you start down.
I agree. I'll note that when I agree with my colleague that the way the instructions happened was that. I will note that the judge noted it was not clear from the defendant's testimony how the stabbing even occurred, because the defendant could not even admit he stabbed him. He was asked multiple times about the stabbing. He wouldn't deny that the victim was stabbed, but he couldn't say he stabbed him.
So just to be clear, is it your position that there was not sufficient evidence to warrant the instruction?
No, I think because it's such a low standard, out of caution, because a jury could assume that he just doesn't want to testify about how he stabbed him, that he didn't remember, if they accepted, I guess. It's tricky because I think it's really a low standard to get an instruction, but I really don't think it may have just met that threshold, but I really don't think it's enough that there would have been. I don't think sufficiency is the right standard when we're looking at prejudice, but I don't think there is enough evidence that a reasonable jury could have returned a verdict here, just because of the physical evidence that really counters his and the eyewitnesses that really suggest his testimony was not credible.
So it wouldn't have been error to fail to give the instruction if the court had chosen not to?
It definitely would have been reversible error. Whether it would have been error, again, the standard is so low that to get the instruction, that I think it's probably best practice to give the instruction, but I think that if the instruction hadn't been given at all, no, I don't think reversible error would have occurred on this record.
What about the burden of proof here? Is that before us at all? The idea that the state had the burden to prove the lack of adequate provocation in the second degree, and it wasn't in the instruction?
I don't think it's been raised properly, and it was not considered by the lower courts below. I think the first time it really has come up is by the amicus brief in this case. And I don't think, obviously burden shifting could be fundamental error, but I just don't see any burden shifting error in this case because the instruction doesn't say that the defendant has the burden of proof. I think at most it's silent about who has the burden, but then all of the other instructions repeat over and over again about how the state has the burden of proof. And notably, because there were justification instructions, they were told the state had to disprove justification. So there's no suggestion that the defendant had some burden of proving something to the jury. So I think even though it's silent on a burden, this jury would not have thought the defendant had some burden of proof here.
And I do notice a little outside the context of this case, but your proposed instruction also is silent on it, which makes me very hesitant to comment on that instruction, at least in a case, which would be unusual. But as Justice Montgomery says, phrasing this in the form of a question, wouldn't it be a good idea to address that in the oral petition? I went back and forth on whether to make that ask, and I know this court no longer approves the Rajis. And as a member of the Raji committee, we really try to get it right. We really do, and mistakes are made. And I don't think our role is to decide questions that haven't been decided by a court. So I think if this court, and maybe it is improper and too advisory to go through the whole thing, but perhaps it would be helpful to note, and again, I don't think the burden question should be decided yet because I think it really should be properly briefed and raised and addressed by lower courts and the parties. But it would be helpful to note, for example, if the verdict form proposal is adequate based on the issues that are presented in this case, that would help allay the confusion, because as much as I love to be here, I don't want to be back here on these new instructions because they're still not adequate. And but again, I don't think we need to address the burden issue.
Ms. Jones, thank you so much for taking the initiative on that. We do not want incorrect instructions out there, so really appreciate your work on that and the defense counsel with whom you worked.
Yeah. Thank you. And I say I'm out of time. If there are no further questions, we ask that you affirm the Court of Appeals.
Thank you. Okay, Mr. Rossi, 4 minutes and 1 second.
Okay. Touching on what the state is doing when it's arguing about prejudice, it's arguing that this court basically be a 13th juror. It's arguing that this court evaluate the evidence. It's arguing that this eyewitness testimony, which was largely rejected because the eyewitnesses claimed this was premeditated. When you say he's got a knife in his hand and he's looking for the victim and he says someone's going to die, that's evidence of premeditation, and this jury rejected that. The physical evidence, the depth of cut, I don't know if I'm in a heat of passion how deep I'm going to cut somebody. That doesn't mean premeditation. That just means the guy died. Now, the question about Lua, does this court need to grapple with the burden issue? We raised it in our supplemental brief to this court. We did not raise it below. And it was obviously explained in much more detail by amicus. But I agree with counsel's last comment, which is looking forward. It doesn't make sense to not comment, for this court to not take that issue up if it's being asked by the state to say, what's the correct instruction?
But at this point, and it would be nice to wrap everything up neatly as far as what the law is on this area, but it hasn't been raised, and so people with an interest in this issue haven't been put on notice that they may want to weigh in. And what I got from the state was, we'd like you to bless this proposed instruction, but only as far as it impacts the issues in this case, which doesn't include the burden. So based on that, I mean, there's no type of structural error here or anything like that we would sua sponte reach out on this, is there?
I understand the court's hesitation, but the court did the same thing in Lua. Nobody asked the court to comment about what's the correct instruction, but the court saw fit to try to make it clear to people, this is the correct instruction. And this court certainly has the power to do so now. We don't want to be back here. If for some reason we prevail, it's going to come up. It's going to come up in another case. And I think looking forward, just as the court did in Lua, it's appropriate to probably weigh in on that issue as well. If it's going to weigh in at all on what's the correct instruction. The other chance argument that the state has raised, it's interesting that the Court of Appeals did not adopt the Eddington other chance argument. That was argued before them, the 13-115B instruction, how, beneath the reasonable efforts instruction, you have this instruction that says, if you have a reasonable doubt as to whether it's manslaughter or second-degree murder, go manslaughter. Again, operating behind a gate that bars consideration of that instruction itself, and Eddington didn't really consider that. Eddington really said, the court has not said this is fundamental error yet. And then they said, but even if it is, this is why that alleviates the problem. But it didn't really analyze the situation very carefully, because you don't get there when you're barred at the gate by this reasonable efforts instruction that says, don't go there. If you have any other further questions, thank you.
Thank you very much. Thank both counsel for your briefing and argument on the case. We'll take the matter under advisement and issue an opinion in due course. In the meantime, is everybody okay staying up here? I forgot to ask that comes out. All right, we'll just stay up here waiting for the next case to come forward.